Good morning. Happy Friday. I had another video that I had already recorded and was mostly uploaded, but then PDocs pulled through. He got me the day 4 minutes from the trial, and there's some yummy stuff in there. The first thing is the defense, when the plaintiff rested, the defense apparently filed a motion for a judgment as a matter of law. It's Federal Rule of Civil Procedure 50A. The judge took it under advisement, which is normally what happens because the judge would rather have the jury come back with the right result. But if the jury doesn't come back with the right result, then the judge may say that's fun and all, but as a matter of law, no reasonable jury could have found as a matter of law that these facts would come to this conclusion, because there you go. And so the defendants have another out. And if the judge doesn't grant it, and if they renew it and the judge doesn't grant it, then they have another appealable issue to the Ninth Circuit, where the Ninth Circuit could, if they find in favor of the defendants, they could actually say, no, as a matter of law, the defendants won, and reverse everything. So the defendants have another out. Very competent attorney skills on their part to do that. I mean, I guess it would just be really stupid to not do that, but they did it, and so that's a good thing for them. Not for Chili, but it's a good thing for the defendants. The defendants only called one witness after the plaintiff rested. That was Officer Bork. That is a pretty good sign that they think that they had most of the other areas covered. There was only one witness that needed to testify. And then they did like 3 hours or something stupid of closing arguments, which is just absurd. Just absurd. Like, I don't know why a court would give that long for closing arguments, but I mean, the court has the power to do that. So, but that's a lot of closing argument. Then the jury basically didn't have any time for deliberation yesterday. They're deliberating today. Generally speaking, you get if the defense is as confident in their case as it seems, and if Chili is as concerned about the case as he seems, then it is likely that we'll get a jury result today. If there is something in there then that is questionable, then the jury might take longer. It's a guessing game. In my experience on criminal actions, which is very limited, a longer jury deliberation is usually better for the defendant. I'm not really sure on civil. I'm not really sure on it. Like, there's no real rule of thumb there. But be that as it may, another spicy little bit of information. Thank you to Big Jim Finch. Those boys are working hard. Support them. Give them some money. Big Jim Finch is spending 30 cents a page on Pacer, apparently, because he does so many Pacer things. So send him some cash. Send him some cash. Be a good boy. Send him some cash. And if PDocs has an account somewhere where you could send him some cash, send him some too, because those two guys supply this community with so much information about these cases. They are invaluable assets, and I really appreciate them. But apparently, our boy Chili Decastro, today's the 13th? Yeah, so today, Chili filed another lawsuit against LVMPD. Didn't see the complaint yet. It hasn't posted, but the information is already in court listener. And Chili is representing himself. Now, what does that tell us? What can we infer from that? Michael Mee is representing him on this case, but not the new case. I wonder why. Well, probably one of two reasons or both. Number one, the second case has even less merit than this case, which is a great reason for Michael Mee not to take a new case under contingency. But what I think is probably even more compelling for Mr. Mee is that Chili is probably a fucking terrible client who refused to take a settlement and forced Michael Mee into what is now 5 days of sitting around with his thumb up his ass, waiting for a jury to come back. So That's probably more. Attorneys, generally speaking, would rather take a settlement than to take the matter to trial and roll the dice. I understand why clients often want to roll the dice, but there is an old saying, and I think there's a lot of merit to it. A bird in the hand is worth two in the bush, and $10,000 can go a long way. Even if you're giving $3,300 to your attorney, $10,000 can go a long way. You can pay a lot of traffic tickets with that, or buy treats for Charlie, or fund a new board game or something like that with that kind of money. So, but good luck to Chili on the new case. Good luck to Chili on the existing case. Actually, more good luck to Michael Me on the existing case, because that boy is going to have, if it goes the way I think it's going to go, that boy worked a long time, put a lot of effort and energy into it for nothing. And I feel bad for him. I feel bad for Michael Me. Anyway, so that's what I got for you today. Oh, one other thing. So Chili was going over his testimony. At least I saw snippets on it from, I believe, Instagram. Basically, he was asked a direct question. Did Officer Bork tell you that you could film? And instead of answering that question yes or no, which is the right thing to do, just say yes or no. Yes. Okay. I mean, it's in the fucking video. So, like, the only reason they're asking you that is because they know, or they hope, that you're going to shit the bed. And what does Chili do? He shits the bed. He says, I didn't have to ask him for it. I have a right, a God-given right, secured by the Constitution, blah, 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 right? Didn't answer the question. There is a reason why I have 5 simple rules. And they're not my 5 simple rules. They're another attorney's 5 simple rules that I picked up, because they are very effective, and they make your witness much more effective on the stand. Much more effective. And those 5 simple rules, for those of you who haven't been around for a while, are pretty simple. Rule number 1, wait 5 seconds. Wait 5 seconds before you answer. Whether your attorney asks it, another attorney asks it, you wait 5 seconds to let your attorney object and to maintain continuity. If you're waiting 5 seconds when opposing counsel asks, but not when your attorney asks, that looks suspicious. The jury will pick up on it. The judge will pick up on it. So you don't want to do that. You always want to wait 5 seconds. Rule number 2, if you could answer a question yes or no, you answer yes or no. If they say, do you know what year you were born? Or do you know what year you were born? If you say, oh yeah, I was born this year, you haven't answered the question. The question was yes or no. Do you know what year you were born? The answer to that question is yes. If they want follow-up, they'll ask you the follow-up. If they forget to ask you a follow-up, and a lot of times opposing counsel who aren't used to the 5 rules will get flustered by it, and they might miss questions or skip things or leave things undone. If they want a follow-up, they'll ask the follow-up. Okay, what year were you born? Then you answer the year, right, after waiting your 5 seconds. So rule number 1 is, if you could answer a question yes or no, you answer the question yes or no, and you stop. If you think that, like, yes will hurt you, you wait for your attorney to come back and ask you a follow-up question so that you can explain it, if your attorney thinks it needs to be explained. So, but rule number 3 is, if you can't answer a question yes or no, answer it in one sentence. Make that sentence as short as possible. Take as long as you need to think about the answer to come up with one sentence as short as possible that answers the question. Succinct is the name of the game. You don't want to go into, back in 1953, I was living in a house with my 3 kids and someone, just shut the fuck up. Just one sentence, short as possible. Rule number 4, you can't always answer a question. You can't always answer it. Sometimes you don't know the answer. If you don't know the answer, you say, I don't know. You don't guess. If there's a difference between an estimate and a guess. If I asked you, how big is my kitchen table? You've never seen it. You don't know. If you gave an answer other than I don't know, you'd be guessing. Nobody wants you to guess. The opposing counsel doesn't want you to guess. The judge doesn't want you to guess. The jury doesn't want you to guess. And I guarantee you, your attorney doesn't want you to guess. Now, maybe you've been over to my house and you've seen my kitchen table. Well, you probably haven't measured it. As far as I know, no one other than me has measured it. Maybe the people who built it measured it, but, whatever, they're not testifying. So unless you've measured it, you don't know. But if they ask you for an estimate, so you say, I don't know, and then they might say, do you have an estimate? Then you can give an estimate, and you preface it by saying, I would estimate, blah, blah, blah. But if you don't know the answer, you say, I don't know. You don't guess. And if they ask you for an estimate, if you can actually give an estimate that's not a guess, then you can go ahead and give it. So rule number 4 is, if you don't know the answer, you say, I don't know. Rule number 5 is very simple. Don't lie. Period. Don't lie. Attorneys, generally speaking, don't ask witnesses questions that they already don't know the answer to. And if they ask you a question and you decide, well, you know what, it might hurt me if I answer it truthfully, and so you lie, what the attorney is most likely going to do is he's going to pull something out that shows that you're lying, or at least strongly infers it. Nothing makes an attorney happier than impeaching a witness on the stand. Why? Because a jury instruction that you can ask the court to give, may or may not get in there, is that if the jury finds that the defendant lied about one thing, they can infer the defendant, or whoever, plaintiff, whatever, the witness. If they infer a witness lied about one thing, they can infer the witness lied about everything. And that is very damaging, because they will infer that the witness lied about things that benefit the witness, that benefit the party who called that witness. So you never want to lie. You just don't want to lie. If you think the answer hurts you, you wait for your attorney to get back up and ask you questions that are going to rehabilitate it. That's your attorney's job. You're not smarter than your attorney, at least not as far as trial practice is concerned. I guarantee you that. I know there's a lot of people saying, I've done a lot of pro per trials. Well, first of all that tells me is you're stupid enough to get in trouble often enough that you get into a lot of trials. That's what that tells me. Your attorney has a great excuse. He's getting paid to go to trial. You fucked up. So your judgment is already suspect at best. But your attorney, I guarantee you, knows better how to rehabilitate you, because your attorney also knows the answers to all these questions, hopefully, before they get asked. And he anticipates what the defense is going to ask, because he knows what's going to hurt the case, or what the plaintiff is going to, he knows what opposing counsel is going to ask. So he should be prepared to ask you the questions that are going to rehabilitate you, to make your answers look better. He's going to craft a narrative using your responses that make you sound like a pure and pristine virgin, right? So anyway, Chili using the opportunity, using apparently multiple opportunities to lecture the jury, to preach to the jury about his particular political beliefs and his particular worldview, is detrimental, to say the least. I guarantee you Michael Meade didn't want him to do that. I guarantee you that the defense was perfectly fine with him doing that. They might have objected to his response after he did it as non-responsive or whatever, but I guarantee you they did not mind Chili preaching to the jury, because it makes him look like a pretentious asshole who knows more than he does, and they've already seen the video, and so they know he's a pretentious asshole who thinks he knows more than he does. Anyway, that's all I got for you today. Thanks for watching. Have a great day.